Hello, my name is Andrew Paulus, and I'm a professor at Case Western Reserve University School of Law in Cleveland. I'd like to take a few minutes to explain my proposal to revamp the way that appellate courts deal with criminal appeals when the defendant's lawyer can't come up with anything to argue. These are commonly called Anders appeals after the 1967 U.S. Supreme Court case, Anders versus California, that first took up the question of what counsel is required to do when faced with this problem. If the defendant can't afford a lawyer, our system appoints one for him, not just at trial, but also on appeal. And that right to appellate counsel stems from a long and proud tradition emanating from the Sixth Amendment right to counsel and the 14th Amendment rights to due process and equal protection. But thousands of times each year, appointed counsel tells the appellate court that there is no good faith basis for appeal. In Ohio alone, where I practice, it happens about 100 times a year, about 600 times a year in the federal system. So think about that. Thousands of times each year, the defendant's lawyer, the one person who should stand by the defendant and do everything possible to reverse the conviction, not only fails to argue for reversal, but actually does the opposite. She tells the court in what has come to be called an Anders brief that there isn't anything to argue. And when I explain that to my law students, particularly after they have taken professional responsibility, they are shocked. But we all should be shocked. When you think about it, it really is outrageous. And it's even more outrageous because the Supreme Court has specifically endorsed a requirement that some states impose that a lawyer in this situation not only has to advise the court that the case is frivolous, but also has to explain why it's frivolous. In other words, the lawyer has to explain the reasons that the potential arguments have no merit. That forces the defendant's lawyer to submit a brief that reads more like the state's brief. Now, once the lawyer submits an Anders brief, the client has a chance to submit something pro se. So now the client, already facing an uphill battle on appeal because of the conviction, has to convince the court that it should reverse his case, even though his own lawyer has said there's no basis for doing so. At that point, the appellate court is supposed to review the submissions and the record and make an independent determination whether there is a good faith basis for appeal. But the cards are already stacked against the defendant, and the prosecution hasn't even filed anything yet. What the appellate court is supposed to do is also a really murky issue. How intensively must that court review the record? Anders suggests that the court has to review the whole record with an eye toward identifying any arguable issue. The idea is that the court is supposed to ensure that the defendant has had the constitutionally required representation on appeal. And it sounds like a laudable goal, but is it a reasonable one? The court, in reviewing a case under Anders, essentially engages in the advocate's task of issue spotting, and that's not the court's job. And it's much more than the court even does when a lawyer files a conventional brief. Even if that brief raises only one issue, no matter how weak that issue is, the court confines itself to a review of that issue. But now, after getting an Anders brief, all of a sudden the court is supposed to take on a quasi-advocacy role. And that's just nuts, especially factoring in the resources the court must bring to bear for 3 appellate judges and their clerks to review the record with no purpose other than determining if the lawyer has spotted all of the non-frivolous issues. These problems have convinced about 10 states never to permit counsel to file an Anders brief. In Ohio, we have 12 appellate districts. Most permit Anders briefs, but 3 districts have said no more. But banning Anders briefs only whitewashes the problem. What is an appellate lawyer supposed to do if there really is nothing he can identify to argue on appeal? We have to fix this problem, and I have a proposal for doing just that. Let's end the practice of having a lawyer explain to the appellate court why her client's case is weak. Indeed, let's take the court out of the equation completely. Let's instead adopt a robust system of successive counsel, each of whom reviews the record the way a lawyer should. The first appointed counsel files a brief if she can, but if she's unable to identify a non-frivolous issue, she passes the case to a successor. The successor, aware that the first lawyer has found nothing, should get a higher fee if she identifies something worth pursuing, and if she doesn't, she passes it off to a third lawyer who should be eligible for still a higher fee if he finds a good faith basis for appeal and pursues it. When 3 successive lawyers all agree, however, that there's no good faith basis for appeal, they should advise the client, and at that point, the client can proceed pro se or find another lawyer if possible, but the court should not get involved in evaluating the lawyer's work. The lawyers have ended their professional obligations, and the client has had the benefit of the advice of not 1, but 3 lawyers. The constitutional right to counsel is protected, and even though no counsel has filed a merit brief, they have at least spared the client the disloyalty of briefing the case against the client, as the Anders process requires. Of course, we must make sure that appointed counsel have the chops to do their jobs properly, so at least one of the 3, and perhaps the last of the 3, should be a seasoned lawyer on whom the court can reliably depend to evaluate the case. Keeping track of the number of times an appointed lawyer has found nothing to appeal would also be important, particularly if one of the successor lawyers comes to a different conclusion. In other words, to qualify to be an appointed lawyer, a lawyer should not have a troubling history of declining to brief a case that other lawyers have shown a willingness to brief, and that would ensure that a defendant does not fall victim to sloppy or lazy lawyering. With that protection in place, the court should readily permit counsel to withdraw with no explanation required when 3 lawyers all agree there is nothing to appeal. At that point, the court should make it clear to the defendant that she still can submit a brief, but the court will not appoint another lawyer to represent her. If the defendant chooses not to file a brief, the court should dismiss the appeal safe in the knowledge that the defendant was afforded her constitutional right to counsel. And what if all 3 appointed lawyers somehow err in their judgment? The judicial system already has a built-in safeguard for that. A defendant whose appeal has been dismissed should have the right to reopen the appeal if she can show that her court-appointed lawyers provided ineffective assistance of counsel. Ohio and other jurisdictions already have appellate rules that allow an appellate court to reopen an appeal under these circumstances when the defendant demonstrates ineffective assistance, including counsel who improperly file an Anders brief. Those rules already exist, and they would guarantee a remedy to a defendant who can show that all 3 appointed lawyers were ineffective in not pursuing an issue on appeal. This proposal spares the lawyer the dilemma that can arise when counsel's duties to the court and to the client conflict. It also spares the court the burden of taking on the role of an advocate, and it offers the criminal defendant greater protection on appeal than our current system because the defendant benefits from the advice of not only 1 appointed lawyer, but up to 3. That's my proposal. For more, please read the article I have written, which at the time of this recording is forthcoming in the Akron Law Review. I'm Andrew Paulus. Thanks for your time and attention.